Hi, thank you very much for having me today. Again, my name is Susan DeClercq. I'm an Assistant United States Attorney in Detroit, Michigan, and with me today is Ellen Bowden McIntyre, who's an Assistant United States Attorney here in Nashville, Tennessee. The U.S. Attorney's offices are part of the United States Department of Justice. There are 94 U.S. Attorney's offices across across the country, at least one in every state. We prosecute federal crimes. We defend the United States when it gets sued, and specific to what we're talking to you about today, we also enforce federal civil rights laws. Today we're going to be talking to you about a few federal laws that protect people with disabilities against discrimination. The most important of these is the Americans with Disabilities Act. We'll focus on a few different areas of life where discrimination often arises, and then we'll give you information on what you can do and who you can contact if you believe that you have suffered discrimination. Okay, so let's talk about the Americans with Disabilities Act, also called the ADA, which is how I'll probably be referring to it. It was enacted in 1993, and it was amended in 2010. It is a comprehensive federal mandate to eliminate discrimination on the basis of disability and to ensure the integration and inclusion of individuals with disabilities in all aspects of American life. The ADA protects individuals with disabilities in virtually all areas of life, but the statute itself is organized into three distinct realms. Title I involves employment, Title II involves public services, and Title III involves public accommodations. And we'll talk about each one of those through this presentation. So specifically, who does the ADA protect? It's someone who, it's first of all, individuals who are disabled. And the statute defines a disability as someone with a physical or mental impairment that substantially limits a major life activity. Major life activities are things like walking, speaking, seeing, etc., but like specifically for EB, it can also include major bodily functions such as normal cell growth, skin resilience, and healing. The ADA also protects someone who is regarded as disabled, as well as someone who is associated with a person with a disability, such as a parent, a spouse, or companion of someone who has a disability. There are a couple of very important exceptions to the ADA, where the ADA does not apply to churches or religious organizations. It also does not apply to employers with less than 15 employees. It also does not apply to private membership clubs or Native American reservations. So now I'm going to talk about some of the most common types of discrimination that arise under the ADA. Those are architectural discrimination, policy or practice-based discrimination, communication-related discrimination. And so we'll go through each one of those. Architectural discrimination is where, because of some sort of architectural element of the physical layout of a building or an area, it's inaccessible to someone with a mobility disability. So for example, if there's no ramps, no elevators, the doorways are too narrow, or there are no designated parking spots, that is considered to be architectural discrimination. The ADA is a statute, but it also has regulations that provide very specific details about architectural accessibility design standards and the level to which a building is required to adhere to those very specific standards depends upon when the building was constructed in relationship to the ADA. So for example, if it's a building that was constructed after 1993 when the ADA was enacted, it must comply strictly. So even if it's a couple inches off, it would still be considered to be a violation of the ADA. However, if we're talking about a building, a historical building, or any building that was in existence already at the time of 1993, the owners are actually only required to make what's called modifications that are readily achievable. And that means that it's accomplishable without much cost or expense or difficulty. So for example, installing one ramp at one entrance or installing grab bars in a restroom, those are all considered to be readily achievable modifications that even historic buildings really should be doing. There is a middle ground when you have a building that was constructed before the ADA but then was later altered after the ADA, and in that case, it's the owner must modify the building to the maximum extent feasible. So it's this middle ground. The next most common type of discrimination is policy or practice-based discrimination. This often comes up in the context of an entity that will have a facially neutral policy that adversely affects people with disabilities. So just to give you an example of what this means, the perfect example is service animals. So many businesses may have policies prohibiting animals on their premises, especially restaurants or hotels, things like that. But this policy adversely affects people who have disabilities who require the use of a service animal. And so the ADA requires that the entity make reasonable accommodations to their normal policies to allow the service animal to come. They can't charge extra, things like that. And there are a number of other different kinds of policies that can be required to be changed to ensure that a person with a disability can access the services of that business in the same way as the general population. Another very common type of discrimination involves communication. The ADA specifically requires entities to provide auxiliary aids and services where it's necessary for effective communication for people with communication difficulties. So for example, a hospital must provide free of charge to the person a sign language interpreter if the patient or family member is deaf. Now I want to talk about sort of different areas of life that are covered by the ADA. And the first is employment. This includes private employers as long as they have 15 or more employees. It also applies to state and local governments as employers, employment agencies, and labor unions. The ADA covers all employment practices, including recruitment, compensation, benefits, terms and conditions of employment, things like that. And what the ADA requires employers to do is, of course, not discriminate on the basis of disability, but also to not allow harassment because of disability, including by coworkers. Also, employers cannot retaliate against their employees for exercising their rights under the ADA. And most importantly, and this is the most unusual portion of the ADA as compared to other employment discrimination laws such as Title VII, the ADA requires employers to provide reasonable accommodations for their disabled employees. Now, what is a reasonable accommodation? It is any change in the job environment or in the performance of the duties of the job that are necessary to enable a qualified individual with a disability to perform the essential functions of the job. Also, it must be reasonable. So that means that the accommodation that is requested and that they must provide must be feasible or plausible, taking into account the size and relative resources of that particular employer. So what might be considered to be reasonable for Microsoft might not be considered to be reasonable for a local elementary school to do. So then the purpose of this is not only to make sure that people are not being discriminated because they have a disability, but it's also to break down any of the kinds of barriers that exist in an employment context to people with disabilities. Some common reasonable accommodations include physical changes to the workplace, such as requiring an employer to install a ramp or move an employee's cubicle to closer to the restroom if that's what they need. Another very common reasonable accommodation is asking the employer to acquire or modify their equipment so that the employee who needs it can access it. So for example, communication software, or even just a back pad for a chair for someone who has spinal problems can be considered to be a reasonable accommodation under the ADA. A reasonable accommodation can also be allowing the employee to change his or her work schedule or to be given additional time off if they need to for medical reasons. However, it's important that any accommodation that is requested must not interfere with the essential functions of the job. And what is considered to be an essential function of the job really depends on each individual particular position. Another federal statute that can assist in situations where an employee might need additional time off for medical reasons or to assist their family with medical reasons is the Family and Medical Leave Act, or the FMLA. The FMLA allows eligible employees to take up to 12 weeks of unpaid leave off without the fear of losing their job or their health insurance. The FMLA, however, applies only to employers with 50 or more employees, which is different than the ADA, which applies to employers with 15 or more. And the employee has to have worked at that place of employment for at least 12 months before taking FMLA leave. And before we leave the area of employment, there's one more federal statute that I wanted to mention, especially in this context, and that's GINA, the Genetic Information Non-Disclosure Act. This act, which was enacted in 2008, prohibits employers from asking employees or prospective employees about any genetic information, including their family medical history. It also prohibits employers from using any genetic information that they may already have in making any employment decisions. This is not to say that employers can't still have employees submit to medical examinations as part of the job, such as a fitness for duty examination for a police officer or a labor-intensive job. Those fitness for duty examinations are fine because the focus of those examinations are what is the employee's physical capability today? Can they do the job today? But what GINA prevents is an employer making a decision based upon what might happen in the future depending upon that person's genetic background. Now, if you believe that you have been a victim of employment discrimination, you need to contact the EEOC, which is the Equal Employment Opportunity Commission. I've listed here their website and their telephone number. They have 53 field offices across the country, and they each take complaints within their own region. One really important thing to remember, though, is that under the statute, you only have 180 days from the date of the alleged discriminatory act in which to file with the EEOC. If you miss that 180-day window, your claim may be rejected or dismissed. Okay, so turning to another area of life, the ADA, specifically Title II, also applies to state and local governments and governmental services. So this includes, among other things, police departments, jails, county hospitals, and public schools. So what this means is that state and local governments must make their buildings accessible. They must make reasonable modifications needed to allow people with disabilities to access their services in the same way and to the same degree as other people, and also to ensure effective communication with people with disabilities. Because the ADA applies to public schools, this means that the ADA can also provide some protection against bullying in schools if the bullying is being done because of the student's disability. If that's the case, it is no longer simply bullying, and it rises to the level of what is considered disability harassment, which is prohibited by not only the ADA, but also the Rehabilitation Act of 1973. Disability harassment is intimidation or abusive behavior based on a disability that creates a hostile environment by interfering with or denying a student's participation in a school program. So what we're talking about here is not the occasional teasing that might hurt someone's feelings. We're talking about harassment that is so severe and pervasive and happens so often that the student is effectively being denied the ability to take part in school or school-related activities. This can take on, here we go, a variety of different forms, including verbal harassments, physical threats, or threatening statements. It also includes conduct that is located in all areas of the school life, not simply classrooms. It can also be on playgrounds, on the bus, during after-school sports, or any sort of school-sponsored activity. If these things happen, if disability harassment is occurring, the school must investigate the incident and must respond appropriately. And if the school fails to do so, that could be a violation of the ADA or the Rehabilitation Act. If you think that your child has been harassed on the basis of his or her disability and you feel that the school district did not appropriately respond, you can file a complaint with the United States Department of Education, Office of Civil Rights, and here is their email address, but you can also file a complaint with the Department of Justice in the Disability Rights section, and then that is the website for DRS right there too. Now, the last area covered by the ADA is probably the largest, and it's called public accommodations. That is any private entity or business that holds themselves out or their services out to the public. So that includes, sort of the whole gamut of life: restaurants, doctor's offices, stores, schools, daycare centers, hospitals. Pretty much the only thing that is excluded from that particular area of the ADA are, again, churches, synagogues, any religious organization, and parochial schools. So again, like the local government and state governments, this means that any private business that's holding themselves out to the public, must ensure that their buildings are accessible. They must make reasonable modifications to their policies and practices to allow people with disabilities to access their services, and they must ensure effective communication. If you believe that you've been a victim of discrimination by a public accommodation, as opposed to employment or schools or a state or local government, your main source of complaint would be to call the U.S. Department of Justice or your local U.S. Attorney's Office. At this point, I'm going to turn it over to Ellen, who's going to talk to you about the Fair Housing Act.
Thank you, Susan. Again, I'm Ellen Bowden-McIntyre, and I wanted to just briefly mention some of the protected areas under the Fair Housing Act, because some of them differ in terms of we have additional protected classes covered by this law. Some of them are ones that you would be familiar with, like race or color, religion. Sex is also covered by that, national origin, and disability. Familial status is a little bit different. It was added to the act later on because there were so many apartment complexes that didn't allow children or had limits on the number of children. So I wanted to point out that the Fair Housing Act covers a lot of different areas, and I'll be giving some examples later about some of the cases that we've handled, but I just wanted to briefly mention that, and now Susan can come back.
Okay, so up to this point, we've talked about what could be a violation and where to file a complaint. The next step is what kinds of remedies are available if the ADA is violated. And this depends in large part upon who is trying to enforce the ADA. So any person who believes that they've been discriminated against in violation of the ADA can get an attorney and file a private lawsuit in federal court against the individual or entity that they believe discriminated against them. However, through that lawsuit, the private plaintiff can only get what's called injunctive relief, and that is a requirement that the defendant perform some sort of specific action to remedy the violation. So, for example, if it's an architectural barrier case, they might be required to put up the ramp that they should have had, or to train their employees better. The private plaintiff can also get attorney's fees if their suit is successful. But what a private plaintiff cannot get, even if they are successful and can prove a violation of the ADA, is they cannot get money damages. They can't get compensatory damages, and they cannot get punitive damages. If, however, the United States, through the Department of Justice and the Attorney General of the United States, files suit alleging an ADA violation, they actually can get compensation for the aggrieved victims of the discriminatory act. They can get the injunctive relief as well, but what they can get is money damages. And that's why it is very helpful for people to file a complaint with the Department of Justice, because the Department of Justice can then take a look at the complaint, see if they want to get involved, and if they do, they can file a suit on behalf of the United States, which often will get defendants' attention, much more strongly than if it was just one individual person. But again, we can get money damages for victims, and then we can also get a civil penalty to be paid to the United States. So now I'm going to talk about the case that Rita mentioned, and that is a case that I handled in the Eastern District of Michigan involving a family who had children who have EB. and it was the United States versus Corral of Westland. And this is a picture of the lovely family, the Cripps girls. I believe there are more of them now, but at the time of our suit, there were only 4 of them. We received a complaint from a mother of 4 who had tried to eat dinner at Golden Corral, which is one of those buffet-style restaurants in a suburb of Detroit. It was a warm spring day, and the children were wearing short-sleeve shirts and shorts that exposed their arms and legs and revealed scabs and wounds from EB. The mother told us that when she and her daughter sat down, the manager of the restaurant quickly approached them and demanded to know, "What is wrong with your baby?" The mom responded that there is nothing wrong with my baby, but she explained that her daughter had EB and it was a genetic disease. The manager replied, "Well, she's got scabs all over, so obviously something is wrong with her." And he said, "I have a right to ask if it involves a contagious disease." The mom again very patiently explained that her daughter did not have a contagious disease, it was a genetic condition, and that they were not contagious or would harm anyone in any way. The manager claimed that customers had complained to him that they felt uncomfortable about the girl's presence in the restaurant because they were concerned that they were going to somehow contaminate the food at the buffet. And so then at that point, the restaurant manager told the mother that she and her family had to leave the restaurant immediately. As you can imagine, they were very upset. Some of the girls were crying, and I think it was her oldest daughter who actually turned to her mom and said, "Are they making us leave because we have EB?" So after we received that complaint, my office opened an investigation. We interviewed the family, and we talked with lawyers for the Golden Corral, and we determined that there was indeed a violation of the ADA. So we filed suit in federal court on behalf of the United States, naming as defendants the Corral of Westland, which was a franchise of the National Golden Corral Corporation, and then the owners of the franchise, Mr. and Mrs. Patel. The basis of our suit was that by kicking this family out of the restaurant because of the appearance of their children's skin, defendants denied them equal enjoyment of the restaurant's goods and services on the basis of disability. For the 3 children who had EB, it was discrimination based on disability. And for the mom and the 1 daughter who didn't have EB, it was discrimination on the basis of their association with someone who had a disability. So after we filed suit, after a few half-hearted attempts to try to justify that the restaurant manager's behavior was okay, they eventually did agree to settle the case. The defendants agreed to pay $10,000 in damages to each person, to the mom and 4 kids for a total of $50,000. And then they also agreed to pay a civil penalty to the United States in the amount of $10,000. We also got the defendants to agree to injunctive relief, such as enacting a non-discrimination policy and changing their practices with regard to how their employees interact with people with a disability. And we also got a requirement that they train every single employee on the ADA on a regular basis. So we were very happy with the results of that case. It was a great case with a great family, and I think a great result. And we hope that, even more important than punishing these defendants for violating the ADA, this case would illustrate to these 4 girls in particular that what happened to them on that day was wrong, that it should never have happened, that they should never be ashamed to be out in public, and that this is not tolerated by anyone, including their government. And so this case is just, sort of one case of a variety of different civil rights cases that the U.S. Attorney's offices handle all over the country. And I'm going to turn it over to Ellen. She's going to talk about some recent civil rights cases that they've had here in the Middle District of Tennessee in particular.
Well, obviously, Susan did an excellent job on that case. Although we haven't had a case involving EB in the Middle District of Tennessee, which is the Nashville area and some surrounding cities and rural areas, we have had, a wide spectrum of other cases that have come to our attention where people file complaints and then we've ended up handling them. One type of case that I enjoyed working on was in Mount Juliet, Tennessee, which is sort of a town that's now kind of like a suburb near Nashville. There was a parent who contacted us, and the parent had a daughter who had cerebral palsy and used a wheelchair and basically needed van accessible parking. And he found that there were a lot of businesses in the Mount Juliet. He actually filed 2 separate letter complaints listing a slew of businesses that lacked, in his opinion, van accessible parking. And unlike in Susan's case where the United States actually filed a suit, we started out by investigating these areas. So I sent out my paralegal to basically, measure the parking spaces and take pictures and that sort of thing to determine if, in our opinion, the van accessible parking spaces were adequate and met the requirements of the Americans with Disabilities Act. And for those instances where we thought there were violations, we then contacted the businesses, and we were able to enter into a number of resolution agreements in which they agreed to make their parking accessible. We provided them with the requirements so that, they knew exactly what they had to do. And by the way, what this means, y'all may already realize this, but as opposed to just a regular handicapped accessible space, a van accessible space has to have additional footage on the side, and it also has to have a special sign that says van accessible. And so there were many businesses in this area that just didn't have that space, or even if they had something that was arguably van accessible, it really didn't meet the requirements. So at any rate, we were very pleased with that outcome, and pleased that we made a lot of businesses in that town come into compliance with the parking standards. Another recent case that we had involves Microtel Inn. To me, it seems slightly similar to Susan's case in that it involved a hotel, and the customer came in with his family, and the customer was blind, the dad, and he had a seeing eye dog, and the hotel did not, said that dogs weren't allowed, and was not kind to him at all about it, and, said you can go elsewhere. And so the United States, after trying to resolve the matter, the United States did end up settling the case, and made them, they ended up agreeing, of course, to have a reasonable accommodation policy and modify their no animal policy to permit people who had service animals to use the hotel. And there was also a civil penalty of $20,000 paid to the United States. Another case that we've handled involved a Fair Housing Act and ADA case against Murphy Development. And this was a pattern or practice suit involving Murphy Development, which owns about 21 large apartment complexes in Middle Tennessee. And this was sort of your basic inaccessible to people with disabilities kind of case, in which there needed to be, it did not satisfy the ADA, and they needed sort of major architectural changes in order to come into compliance. And that case settled, and then in an unusual turn, they still didn't follow the terms of the consent decree. And so the United States had to file a motion for contempt, in which we sort of got them to agree again, and then since then they've followed those steps, but sometimes it can take extra work. And the last one I wanted to mention involves Legislative Plaza, which, if you're not from this area, you may not realize, but that's our capital. So the capital of the state of Tennessee, which is lovely, but obviously a historic building like most capitals, and it had some areas which were not in compliance with the ADA, and so with the United States, they agreed to make changes within 2 years. Some of that involves signage to make it more visible to people who use a wheelchair. Some of that involved creating better accessible entrances, especially for bathrooms and public hearing rooms. So through these changes, we've been happy to, hopefully make a difference. And we hope that some of this is useful to y'all out there in the EB community.
And this is again just where to file a complaint and how to do it. So thank you so much for having me.